Our first case for oral argument this afternoon is number 19, People versus Lawrence Watson. Ms. Poole? Good afternoon.
Good afternoon, Your Honors. Dana Poole for the People, the appellant in this case.
Would you like some rebuttal time?
Oh, yes, please, Your Honor. If I could reserve 3 minutes,
3?
please. Thank you. The issue before this Court is whether Justice Carruthers abused his discretion as a matter of law when he relieved New York County Defender Services attorney Lawrence Fisher as defendant's counsel. And in ruling that he did, the appellate division found no error in the judge's balancing of defendant's rights to counsel of his choosing against his right to the effective assistance of counsel. Instead, the appellate division determined that Justice Carruthers had incorrectly found that there was a potential or actual conflict of interest in this situation. But given the facts presented to Justice Carruthers, there can be no doubt that he correctly and properly realized that such a conflict did in fact exist. First and foremost, Mr. Fisher himself reported that he and his New York County Defender Services supervisors had reviewed the situation and determined that a conflict existed. And Justice Carruthers had no reason to second-guess that evaluation.
Well, what about the defendant? What was his position with respect to this?
Colloquially, he wanted to have his cake and eat it too. He did want to keep Mr. Fisher as his counsel. They did seem to get along. Both of them wanted to continue their working relationship. However, defendant also informed the judge that he wanted Mr. Stevens called as a witness in this case. So,
was there ever a sort of a conclusion reached on that before the judge stepped in and said, you know, well, this is what we're going to do here? So, in other words, do we know whether he would have actually waived the conflict? And does it matter?
Ultimately, I don't think it matters, given the situation. But what we do know is that Mr. Fisher had reviewed the situation with his client before they went into court. And he did not come in and say, my client fully understands and he would like to waive this conflict. The result of defendant's conversation with his attorney was that he still had questions about the matter. And so after counsel presented the situation to the judge began what appears to be a Gomberg inquiry to see if defendant did wish to waive this possible conflict. And as he began to explain the situation to defendant, he asked if he understood, and that's when – and defendant said he understood, but he immediately informed the judge that, in fact, he did want Stevens called as a witness.
In response to that, defense counsel essentially said, I have no problem with that if the prosecution is unable to call Stevens, too, because I won't be able to cross-examine him. So what was wrong with that?
Well, what counsel said is, I can't call Stevens as a witness. So there was this conflict between what defendant wanted, which was to have Stevens called as a witness, and his counsel's ability to carry that out, or at least to investigate whether that was a viable defense strategy. Because what he and his supervisors had determined was that he could not search for Stevens, he could not talk to Stevens, he could not call Stevens as a witness, and were the people to call Stevens as a witness, he couldn't cross-examine him. So there were, in essence, sort of two conflicts happening here. The one was between defendant's wishes and his counsel's abilities, and the second was that the people then informed the judge that if the defense didn't call Mr. Stevens, they would consider calling Stevens as a rebuttal witness.
So is it your position, counsel, that the waiver, or not waiver, but keeping Mr. Fisher on was conditional, that as long as he could call, as long as the defendant could call Stevens as a witness, he would like to keep Mr. Fisher, but if not, then Fisher would be relieved?
The inquiry did not go quite that far, because once it was established that defendant did want to call Stevens, and he was very clear about that fact. And we know that Justice Carruthers properly understood that defendant even in that moment, wanted to call Stevens, because after the trial, when Stevens, in fact, was not called as a witness, defendant still complained about that fact. He filed a pro se 33030 motion in which he complained that Stevens had not been called as a witness. Even at his sentencing, he complained that Stevens had not been called as a witness and posited that perhaps the verdict would have been different. So we know that that defendant was very sincere in his desire to have Stevens called as a witness. He wanted to talk about Stevens at his trial, based apparently on something he had said at the station house when they had both been arrested together. And so what the judge is faced with is this very real conflict. And the judge, this is a very experienced judge, and he is well aware that once a defendant says, I want him called as a witness, and his attorney says, I can't do that, and I can't even cross-examine him if the people call him, the writing on the wall is clear that should this attorney remain on the case, there's going to be an ineffective assistance of counsel.
Well, I don't recall, was the defendant given that choice of saying, in other words, you can call Stevens, in which case you're going to have to get a new lawyer, or you can go with your lawyer, but you're not going to be able to call Stevens. Which couple do you want to drink from? He did not get posed with that particular question. That's true. The inquiry did not go that far, because at that point, this very experienced judge realized what was happening in this case.
Is it within the judge's discretion to make that determination regardless of what the defendant
Absolutely.
does or doesn't want?
Absolutely. Because at that point, once he had said in the face of all of this information, I want Stevens called as a witness, even if the inquiry had gone on and he had said, well, okay, I'll waive the conflict that's presented here, the fact remains, Justice Carruthers knows full well that should that happen, should defendant then be convicted, the ineffective assistance of counsel claim.
How serious was the conflict? Because Stevens had already pled out.
Stevens had pled out, but these were related cases,
Right.
and that puts this case in a very different position than many of the other cases.
Or is the conflict created because of what Fisher's supervisors forbade him from doing?
Yes.
I mean, if they hadn't said all that, would it possibly be a different question here?
Well, one of the things that the appellate division faulted the judge for was relying on what the attorneys had said. But even if the judge had determined, oh, I don't, there's no actual conflict here, your supervisors are wrong, there's still a conflict because defense counsel is now inhibited. If he does what the appellate division suggests and goes ahead and calls the witness or cross-examines him, he's acting in direct contravention of what his supervisors have told him, which creates its own conflict because he's looking at being disciplined or perhaps fired for taking those actions.
But
So,
is there a motion to that effect? Or I just, the judge is the one that seems to have made this decision, and I just don't know why I wouldn't have waited for a motion in which maybe the lawyer would have said exactly what you just said. My job's on the line if I call this guy, and so I can't do this. I want to be relieved.
well, Fisher was walking into court saying, he didn't specifically say, I have to be relieved. He sort of relied on the judge to say that and then agreed with him. I mean, I think he didn't want to be the guy in the courtroom saying he could no longer represent his client. But he made very clear that he was in agreement with what his supervisors were telling him to do.
If he had said he could no longer represent his client and then the judge refused to let him go, that would have put him in a much worse position.
Dire straits, and the ineffective assistance of counsel claim writes itself at that point. So the judge is between a rock and a hard place in this scenario. There's no question that there is, at the very least, a potential conflict and probably an actual conflict, and probably both if you look at what's happening with the people and what's happening with the defense. And the judge properly realized that he had to make this balancing determination between the defendant's rights, and he properly opted he properly determined that the safest course of action here was to appoint unconflicted counsel to represent defendant during this trial.
Thank you. Thank you, Ms. Poole.
Thank you.
Ms. Zaitsev, am I pronouncing your name correctly?
Yes, you did.
Miracle of miracles. Thank you.
Good afternoon, Your Honors.
Good afternoon.
The appellate division here correctly concluded that there was no conflict and that Mr. Fisher's disqualification was therefore improper. The appellate division...
How is there not a conflict if the lawyer is essentially saying, my supervisors have told me to stop everything I'm doing on this case, stop investigating, stop looking for Mr. Stevens, because we represented him previously, and I can't look at the file that we have so that even if I don't find Stevens, I might be able to find something if the prosecution calls him. And if I don't do that, then, you know, essentially I have to get my client to waive any conflict that there might be and allow me not to call Stevens or not to cross-examine him. And the defendant is saying, no, I don't want that. I want you and I want Stevens. So where is that not a conflict?
Well, Your Honor, any attorney that would have been assigned to represent Mr. Watson would not have been able to access New York County Defender's confidential file on Mr. Stevens. So the fact that...
the only thing that could create a conflict here?
No. Clearly, if Mr. Fisher had, for example, worked on Mr. Stevens' case or accessed any confidential information about Mr. Stevens, he would have been conflicted.
But nobody can get the confidential file. You're right. So, I mean, why is that a problem?
It's not a problem.
But someone else could investigate and follow up on Stevens, correct? Put aside the question of the file.
Well, Mr. Fisher likewise could have followed up to investigate on Stevens. The only thing he couldn't have done was access New York County Defender's confidential file and use that confidential information to locate or question Mr. Stevens. So he was in the same shoes.
Are you saying his supervisor said, you can go find Stevens and, you know, find out, you can talk to Stevens, you can do anything you want if you do find him, or you can look up any information that might be public or that you might use to either examine or cross-examine him? Is that what you're saying, the just don't access the confidential file that we had on him?
Well, Your Honor, that's not what the supervisor said here, but frankly, they were incorrect. There was no conflict, and it was the judge's responsibility to clarify that on the record.
But even if they were not correct, wasn't Mr. Fisher in a conflicted situation between his supervisors and his client?
Well, again, if the judge had clarified that there was no conflict created by this situation, Mr. Fisher's supervisor surely would have, one can assume, amended their stance on it.
What if they concluded the judge is wrong? The judge is wrong. We think there's a conflict and we're not going to follow this.
Well, in that case, what Mr. Fisher's supervisor specifically told him was that they believed that this conflict was waivable. And that was a choice that was taken away from Mr. Fisher, from Mr. Watson here. He was not given.
Let me, on the waivable issue, let me posit this to you. What if the court hadn't removed Fisher? And wouldn't you be, as defendant's appellant counsel now, wouldn't you be in front of us arguing that counsel's inability to cross-examine a key witness would have been clear error?
No, Your Honor. There are many cases where waivers like this have been upheld by the court. And People v. Caban is one example. And so there's really no question that a defendant can waive potential conflicts of interest, and that's not a basis for a valid appeal.
Well, the problem I'm having, counsel, is that it doesn't appear, although it's not absolutely clear, that defendant was actually waiving any conflict, because he said, I want you, Mr. Fisher, to represent me, but I also want to call this Mr. Stevens. And essentially he's suggesting to Fisher, I want you to find him and bring him in here so he can testify. So I'm not sure that he was actually, I'm not getting that he actually waived anything.
Well, Your Honor, that's an excellent point because it highlights yet another error committed here by the trial judge. The trial judge explained what the ramifications of a waiver would be and what the ramifications of continuing on with Mr. Fisher would be. In response to that, Mr. Watson unequivocally expressed that he understood what the ramifications were, to the extent that he then...
What was Mr. Fisher's position at that time?
Mr. Fisher's position was that he believed that there was a conflict, but that it was waivable. And if the court would allow Mr. Watson to waive it, he would like to stay on as Mr. Watson's counsel.
Can the court ever decide to relieve counsel, even if the defendant is willing to waive a conflict?
Surely there are cases where a conflict is so severe that...
What would have had to have happened here, for example?
Well, for example, there are numerous cases where the same attorney represented represents the defendant, previously represented the witness that is going to be called by the people.
So a tension that a lawyer might feel between investigating a potential avenue of defense with another witness, that the tension of wanting to pursue that, but not being able to because his supervisors have said you cannot do that, that doesn't present a conflict?
Well, even if it does, again, that goes back to the question of whether Mr. Watson could waive that conflict, and it's under this Court's precedent that's exactly the type of conflict that this Court has repeatedly held is waivable.
But what we're talking about is not whether it can be waived, but whether the Court can take those circumstances and say, I really think that this lawyer is going to be in a catch-22 situation. It's a no-win situation for the lawyer. And regardless of what the defendant says now, because when the time comes and the people put Stevens on the stand and the defendant says, you need to cross-examine him, then I'm going to be faced with a mistrial. So why isn't that appropriate?
Well, as I said earlier, it was the Court's responsibility here, before disqualifying Mr. Fisher, to ascertain whether there was a conflict in the first place. He could have done that in this case very simply by asking Mr. Fisher if Mr. Fisher had ever accessed any confidential information about Mr. Stevens.
So the only way there could be a conflict is if he actually had confidential information about Stevens.
In this case, given that he works for an institutional defense organization, yes, because the typical imputation rules don't apply. If he were at a private firm, then there would also be a potential conflict created by imputation.
So it's not, I'm sorry, Judge, go ahead.
No, you go ahead.
So it's not just that there are confidences, but as the appellate division said, he has to be privy to the confidences or information that they have for there to be any kind of conflict, is what you're saying.
That is correct, yes, that is what I'm saying. And there are numerous cases that have that stand for that principle.
Did the judge have any obligation to address at least what at some point the defendant is identifying as his real problem here, which is, yes, he's had this lawyer for a long time, but he just doesn't want to wait anymore. It's the nature of the criminal justice, the demands on the criminal justice system where everything's going to get slowed down. He wants to get to trial. He wants to get this done and put behind him. And the judge doesn't respond to that, although he does say, I sympathize with you and so forth, but here's the problem. We have this conflict, without saying, maybe you want to speak to a lawyer about what this would really entail if your concern is in part driven by delay. Should the court have done something about that to try and perhaps resolve this issue that way?
Well, if the court had allowed Mr. Watson to continue with Mr. Fisher, there wouldn't have been any delay. And so I think the court addressed the delay issue when he did disqualify him by saying on the page that you just referenced.
I understand, but I guess I'm suggesting that the client might have been willing to forego this whole issue about the waiver and whether or not Stevens can be crossed and all of this, if he had some sense of what this really entailed to have replacement counsel. If what drives this engine is, I don't want to wait 4 more years for a trial, or I don't want to be stuck in this for months and months. I want to move on with my life.
Well, whatever
that's all I'm saying is it's incumbent upon the judge to try and respond to that concern, which is different from the conflict concern that is obviously in this case.
The judge's responsibility is to make sure that any waiver is a knowing and intelligent one. So whatever the defendant's reasons, whether it's to avoid delay or because he has trust and confidence in this particular attorney, that's the decision for the defendant to make, and to weigh the consequences of the disqualification or of the waiver versus continuing.
Well, but you're sort of arguing for an absolute right for a defendant, and I don't think that is the law. It seems that we're talking about a Sixth Amendment right that has to balance the right to choose your lawyer versus the right to have an effective lawyer, and that's the nub of this. I think that's the core of it, and that's what, because it's a balancing question. It seems that the court has to speak up when they see a problem.
Well, Your Honor, I agree that it is a balancing test. It's not an absolute rule that I'm proposing. What I'm saying is that here, the balancing test has to take into account the severity of the conflict. And here, the alleged conflict was remote, and it was based on multiple layers of speculation.
But didn't Fisher bring this on himself? I mean, wasn't it when he got the Rosario material that he said, I may have a conflict because Stevens, or whatever his name is represented by the same office?
Well, he got the Rosario material just minutes before he first raised this issue to the court.
I know, but I would not. Maybe I get disbarred. I mean, why tell anybody? I mean, why not just say, fine, I'll subpoena Stevens, get him in here, and we're ready to rock and roll, rather than drop this thing on the court and say, gee, and I don't know, obviously, the lawyers involved. I've got this dilemma. Well, so what?
Well, again, at that time, I'm sorry. No. At that time, it was Mr. Fisher's belief that Mr. Watson could waive the conflict, and so he was bringing it to the court's attention.
Why? Just get your client to waive it and move on. You don't have to tell the DA you got an issue. You don't have to tell anybody else you got an issue, and rock and roll. if the DA then wants to wait a minute, what is this that there's two people in here from the same firm? I say, shut up, it's not your problem.
Your Honor, I don't know why Mr. Fisher brought it to the court's attention, but he did, and perhaps he felt that it was his ethical responsibility to do so.
Well, why would he then bring a motion? I get the collaborative nature of trial work sometimes, but I just get mystified by maybe. Why would you come into the court and say, here's a dead possum, do something with it? No, it's your possum. Go bury it. I don't know why it ended up being Judge Carruthers' problem. It just seemed to me that Fisher said, I got a problem, Judge, and solve it for me.
I was not in.
I guess none of us will know that answer.
Cooked possum. What if the court agrees with the people? What is the potential impact on institutional defenders, or is this really limited to the unique circumstances of this case?
Well, I think it would depend on what basis the court agrees with us, but if the court were to agree that there was no conflict here in the first place, that has significant impact on institutional defenders. There are a huge number of indigent defendants that come through the system every single year, and there's a very small number of institutional defense organizations. So to find disqualification in these circumstances would potentially impact hundreds or thousands of defendants' right to counsel of their choosing.
Would that still be the case if it was limited to the fact, not that the same institutional defender had represented, another person, but that person could be an important witness in the case?
I'm sorry, Your Honor, would you mind?
If the conflict was found based on the fact that witness could be that other client could be an important witness in the case, which the lawyer was prohibited from pursuing, if it was narrowed in that way, would it have the effect that you just described?
If it was narrowed so that it only applies when it's an important witness in the case?
Well, obviously it couldn't be narrowed to that sole instance, but if that was the basis of the decision here, rather than just the fact that this gentleman had at one time been represented.
Yeah, I think it would continue to have the same impact, because that's really the typical situation in which this occurs. Pretty much any time that you have, due to the small number of institutional defense organizations, any time you have a witness that has a rap sheet, it's very likely that that witness is going to have been represented by one of the institutional defense organizations, and like perhaps the one that is at issue here.
Thank you. I think we have your argument.
Thank you.
Ms. Poole?
Defense counsel had an ongoing ethical obligation to Mr. Stevens. New York County Defender Services had an ongoing obligation to their former client, and they were not entitled to disregard that merely because they had a new client.
So did they have to find Stevens and get him to waive any conflict as well as getting a waiver from Mr. Watson?
A waiver from Mr. Stevens might have, is one potential way to resolve the question. But counsel couldn't find Stevens up to the point where he'd been looking for him. And his supervisors, who were really in the best position to determine whether there was a conflict here, potential or actual, based on their ethical obligations to these two men in related cases. This is not sort of a Wilkins situation where the witness was represented by the public defender agency in an unrelated case. These are related cases. And the defense has suggested that maybe Stevens would admit to having the gun. He would require counsel at that point. There are all sorts of conflicts inherent in this situation.
Why would he need counsel? Wasn't his case over?
His case on possessing drugs was over. He had not been charged or tried or pled out to anything involving a gun. And the supervisors in this situation were in the position to evaluate their own ethical obligations to both of these men and evaluate what counsel had done. And what we know is that counsel, he got the Rosario disclosures. There was, the case was recalled several times. When he came back in, he said, I have pulled the file on Mr. Stevens. And the other thing that we know that he did.
In regard to the file, could you clarify what file we're talking about? Is it a file that is a public file that anybody can look at, like the NYSED sheet, or is it something that the New York County Defender Service was keeping?
It appears to be the New York County Defender Service file, because what happened, and he doesn't clarify that, but what he does tell the judge is that he's taken two courses of action. He's pulled the file and he has gotten an investigator to try to find Stevens. And when everybody returns to court after the internal evaluation by New York County Defender Services and the judge asks for an update, he says,
Does it make a difference which one of the files, whether it was the New York County Defender Service file or one of the public files?
If he'd pulled the New York County Defender Services file, then I think it's unquestionably that there's an actual conflict that's been created by that. But even if he had pulled a Supreme Court file or something to that effect, there's information that's available to him if he's Stevens' attorney, as a New York County Defender Services attorney, and there's information that's not. For instance, the NYSED sheet, and I believe that the CJA sheet is also sometimes included by the clerks in that packet that's not given out to the general public. And so whatever...
If the court affirms, what's the impact on the DA?
On the
Beyond this case, if any? It's the same question I asked them on the other side. I'm asking you.
Well, I think the bigger impact is on what defense attorneys are supposed to do, because they do have a clear obligation to their clients, former and present.
What is your interest here?
The interest here is that the judge was not incorrect in determining that there was a conflict here.
So you don't want to see a reversal?
What?
You don't want to see a reversal of the conviction?
Right, exactly. And the judges and the judges.
My question was about beyond the one case.
Right, and I think if the appellate division's decision is affirmed, then I think it calls into question how this court views the ethical obligation of defense attorneys, and I think that that's going to be incredibly problematic for everyone to evaluate these kind of situations.
Doesn't this free up the public defenders to more readily be able to defend?
Yes, but at what cost? Because
I thought you were going to argue to have more ineffective assistance of counsel claims. That's
Absolutely.
what I thought you were going.
Arguably, I mean, I suppose if the ruling was,
That's what I was asking the other side before. Wouldn't they just come up and argue, they didn't call the witness that could have gotten me off, there was a conflict, therefore there was ineffective assistance of counsel?
right, and that's the problem that's presented to judges in these situations, and to say that judges have no discretion to weigh what's happening here, and they cannot accept the defense attorney's statement that there is a conflict here. They understand their ethical obligations. They have reviewed what has happened, what is in these files.
Did the court have any other duties or obligations? Same question I asked them with respect to the fact that to the extent this defendant is concerned about a delay in the proceedings, that's what drives this engine. Did the judge have to do anything in response to that?
Well, the judge did, and the judge said, you know, I understand that, and he, from even the first day that the potential conflict had been raised, and the judge realized there was a problem, he said that, you know, there might be counsel that we can get in to take care of this case right away. When they all returned to court, and the judge said, I'm going to have to reappoint counsel, I'm going to try to get somebody who's able to come in right away. The defendant said, the guy you called in but talked to before, he seems really busy. I don't want that guy. And the judge said, okay.
I of course wasn't there, but I just don't know why there wasn't a motion. I really don't, because if I was in a situation similar to this, I suppose, somebody said, well, my boss tells me I can't go find a witness. I say, well, I'm telling you can, and I'm ordering you to, and they cannot stop you from going and finding a witness. I mean, that was absurd. And maybe it wasn't absurd. Maybe there were facts that would tease out that would say it's not. But sitting around holding hands and deciding, well, you know, we're going to throw your lawyer off, we're going to go find you another one, seems odd.
But the judge doesn't have any reason to question what New York County Defender Services has determined is and the only way that he could. Let me just finish this sentence. If he came in and said, my boss tells me that I can't put on a defense, but I want to. So, Judge, I have a conflict. That's you better put on a defense, or I'll report you to the Bar Association. I mean, you got to sort that stuff out. But that's not.
Because the boss says you can't do something, I'm going to relieve you.
But that's not the situation here. Fisher wasn't coming in and saying I disagree with my supervisors. He was saying we did an internal evaluation, and this is what we determined. And the
that's why
only
I thought a motion would be clearer.
But the only way that the judge could have evaluated that situation is to do the type of inquiry that this Court has consistently warned against.
Did you miss my thought about a motion? Do you just disagree that you can't file a formal motion?
I think he could have filed a formal motion, but he was making an oral motion before the Court. So the Court was aware of the situation. The only thing that the Court could have done is called in the supervisors and said, well, will you please reveal to me what the confidential information in your files were and what your defense strategies are.
He could have said, what's the basis upon which you're telling this lawyer that you've hired, that you pay, that he can't defend this guy properly? And let them try to describe how this is impossible.
And as Fisher told the judge, it was because of their ongoing ethical obligations to Mr. Stevens.
But that's a conclusion. I'm not going to debate it with you. It just strikes me that Fisher comes in and says, I got a conflict, but I don't want to be relieved. And the judge says, well, gee whiz, you know, maybe you should be relieved, but I understand maybe you shouldn't be relieved, and then we've got Stevens over here. And there's nothing you can grasp.
But the rules of professional conduct, and this Court itself in People v. Sanchez just a few years ago acknowledged the fact that even legal aid, public defender services, they have ongoing ethical obligations to their former clients.
No one is disputing that. Please don't think that I'm suggesting that they don't have ongoing ethical obligations to their clients. Of course they do. So does the DA's office. So if the DA's office had hired Mr. Fisher and he said, you know, because I've been hired by the DA, I can't represent this person anymore, they'd probably go farther and say, not only can you not, but that district attorney can't. But those would be decisions that would be made based on the ethics. And my only point is that this one seemed to just kind of flow, and typical, because we're an appellate court, we kind of like to have seen a nice motion.
I just think that the only thing the judge could have brought out that wasn't brought out would have been protected information, confidential disclosures, and defense strategies. And this Court has warned against judges doing.
You honestly think that's what was at issue here?
Yes.
Wow. I don't know why you couldn't subpoena Stevens and ask him all kinds of questions.
because New York County Defender Services had represented him in a related case.
Okay. I think we have your argument. Thank you.
Thank you.